Good morning, I'm Jim Copeland, and I'm the Director of the Center for Legal Policy at the Manhattan Institute. It's my pleasure to welcome you here today to present our new Manhattan Institute Civil Justice Report, Greater Justice, Lower Cost, How a Loser Pays Rule Would Improve the American Legal System. Before we begin, I'd like to ask everyone please to turn off cell phones and beepers so they don't disturb our presentation today. And before I introduce Marie, I'd just sort of like to frame the issue here and tell you a little bit more about what we do. A lot of you are some of our regular attendees, but some of you are not. The Manhattan Institute's been around for 30 years now, turning intellect into influence. And for the last 22 or so of those years, we've been active in trying to reform our nation's civil justice system. My colleagues, our senior fellows, Peter Huber and Walter Olson, who will be on the panel today, were early leaders in the intellectual formation of legal reform with their books Liability by Huber and The Litigation Explosion by Olson. And since then, we've worked in various avenues to try to bring to the general public, to policymakers, to the academy, to the media, the ideas that we think are central to reforming our nation's civil justice system. We've done that through popular publications like our Trial Lawyers, Inc. series, which are available outside, as well as through the internet. Walter Olson's overlawyer.com was the first, or is the first that is still in existence of significant legal weblogs on the internet. And the Manhattan Institute's pointoflaw.com web magazine brings together lots of individuals of import around the academy and in practice to comment on these issues. But we've always been, first and foremost, a public policy think tank trying to turn ideas into real implemented solutions. In the area of scientific evidence in the courts, Peter Huber's work in Galileo's Revenge and subsequent books helped to frame for the federal courts and subsequently state courts the way in which courts handled evidentiary presentation, handled scientific evidence in the courtroom through the Daubert Rule and its progeny. When it came to class action reform, we published a series of empirical studies that formed the intellectual basis for the Federal Class Action Fairness Act of 2005 that really was the most significant federal reform in at least a decade in trying to get large class action lawsuits out of small state courts that were subject to political pressures. And it's in that vein that we today are going to have Marie Gryphon, my new colleague and senior fellow who's been with us a little over a year, presenting this civil justice report on loser pays. Loser pays, or the English rule as it's sometimes called, is really the rest of the world rule. And it's the basic principle that if you lose in court, you pay the other side's legal fees. I'm not going to go into detail about what loser pays is and the pros and cons because Marie's going to do that in her presentation. But I do want to start with a couple of anecdotes that I think highlight the importance of the loser pays reform. One is an example which those of you who've been paying attention to the newspapers should be readily familiar with, and that's the example of Sue and Jin Chung, the dry cleaners who immigrated to the United States in 1992 from Korea and set up shop with their little local dry cleaner, just like many of those around here in Manhattan, in the D.C. area. They were sued by then administrative law judge Roy Pearson for what ultimately was an ask of $54 million for a disputed lost pair of pants. Now, the dry cleaners disputed that they ever lost the pants. He claimed that they gave him a different pair of pants. The point here is not simply the sort of fantastic claim that's made. This is indeed an outlier case in terms of the claim, and you have what is known as, to some degree, an irrational plaintiff. And I hope that Judge Pearson doesn't sue me for calling him irrational. But the point here is that even though they won their case, although it's now on appeal, the Chungs were out about $100,000 in legal fees and expenses. So even though they won, they lost. They were running a small business, and they were out all this money. And even if they'd been dealing with a rational as opposed to an irrational plaintiff, It's far from atypical that they would have done what they did, which is offer $12,000 to settle the case. Now, the pants weren't worth close to $12,000. I assume there may be pants out there worth that much, but I don't think this administrative law judge was wearing them. Why were they willing to wager so much money, or to offer so much money to get rid of this case? Simply because they knew they'd be out significant legal fees once this case actually went to court, even though they were likely to win the case. The other example I want to bring up is one that we focused on in our Trial Lawyers, Inc. series earlier this year, and it's moving from the small business context to the big business context, and that's the mass tort of asbestos litigation. For many years we've been focused on this. We've had Professor Lester Brickman at Cardoso here talking about the rampant fraud which has now been uncovered in federal court with asbestos litigation, where hundreds of thousands of claims a year at one point were being filed, and as many as 90% of those were for individuals who did not have a cognizable medical injury. Now, why did this happen? In part, this happened because there's not a real way to implement legal fraud rules in our courts and what have you. And in part, it happened because that's the nature of the litigation business today. But it's important to realize that the American rule, where you eat your own legal fees even when you win, is a significant underpinning of mass tort fraud as well, because it's impossible for companies to go in and evaluate each individual claim and try to press those through to resolution when they have a winning case, because it's going to cost more for them to do it than they're able to it costs much more for them to do it than they're going to be able to afford. So they're going to settle the cases on the cheap, and that creates the very demand for many of these mass tort cases in terms of the fraudulent cases that are generated in that type of litigation. So we think that the loser pays rule is, excuse me, and I think I've been hitting something here. I'm sorry. Okay. We think that the loser pays rule is an important component. It's not the sole answer to legal reform, to cleaning up our civil justice system, but we think it's an important component. So I want to bring forward our senior fellow, Marie Gryphon. Marie is a licensed attorney, or has been a licensed attorney, a practicing attorney. She's also been a policy analyst in education policy with the Cato Institute, and she's finished all her coursework for her PhD in public policy from the Kennedy School of Government at Harvard. She's a very bright young scholar. We're excited to have her here, and we thank you all for coming to hear what she has to say. Thank you.
Now, you've just heard a lot from my colleague Jim Copeland about the high cost of what we call abusive litigation. Lawsuits filed by plaintiffs and lawyers who are pretty sure at the outset that what they have is a losing case, but who press their claims anyway, usually in order to obtain a settlement from the targeted defendant. We're here today to explore the possibility that a loser pays rule can reduce abusive litigation and increase the overall justice of our legal system. I'd like to begin briefly by describing our current system in terms that will allow us to see how a loser pays rule could change the kinds of lawsuits that plaintiffs' lawyers would choose to file. It's helpful to think of cases as varying in three very basic ways. First, they vary in terms of the number of hours worked. The graph you see depicts the litigation universe in 2 dimensions by holding this third dimension constant. Basically, the graph depicts everything else that we'll talk about today on a per-hour basis. Second, cases vary in terms of how much is at stake. This graph measures the expected monetary value of lawsuits on the y-axis, with very high stakes cases up there near the top and more modest claims closer to the bottom of the chart. Finally, cases differ in terms of how legally meritorious they are, which is reflected in this slide on the x-axis as the probability that a defendant will be found liable. Meritorious cases are on the right side of this graph. As you can see, there's a shaded portion of the graph on the far left-hand side that represents abusive litigation, low-merit lawsuits that are filed in order to coerce a settlement from the targeted defendant, or, in the case of very high-stakes low-merit suits, the possibility of, quote, hitting the jackpot with an enormous trial award. The curved lines represent a typical trial lawyer's financial break-even point for a given case, assuming that case goes to trial under both the American rule, which is the more sort of lazy curve you see there, and under loser pays, which is the more vertical curve that you see there. Do lawyers file suits that fall below these lines? Yes, they do. And the reason they can is that more than 90% of all cases that are filed in the United States, and actually in most other countries, settle before they ever reach trial. But the amount of settlement will depend on what the likely result at trial would have been. So a lawyer's actual portfolio of cases under each system will fall slightly below these curves, but will be parallel to them. Curves can be parallel, and will move directionally in the same way in response to changes in the rules of the game. As you can see, this graph illustrates what virtually all researchers who have studied loser pays agree would happen to the population of lawsuits filed under a loser pays rule. In order to make the same amount of money, our typical lawyer here would have to select more meritorious cases and file fewer abusive lawsuits under loser pays. I want to emphasize that even a lot of researchers who oppose loser pays for other reasons, because they believe that it has other problems, agree with this and think that this much is true. So loser pays appears, at first blush, to be an attractive remedy for the problem of abusive litigation. The real controversy surrounding loser pays is the possibility that it will have negative side effects. There are four main concerns about the possible unintended consequences of loser pays. First, some researchers worry about a possible flood of newly viable small meritorious suits. Those are the ones that are in the lower right-hand portion of the graph that you can see here. Now, these are people who deserve justice and don't have it under our current system. So I frankly think that that should count as some benefit, even if there's some social cost attached to that. On the other hand, it would be a shame if those suits turned out to be so numerous that the transaction costs of sorting those suits out were just as high as the transaction costs of the abusive litigation that we're trying to limit. Fortunately, there's reason to believe that that's not the case, that the reduction in abusive suits will be greater than the increase in small meritorious claims. You see, some small claims are currently litigated as class actions, and so would not be new additions to the pool of potential claims under loser pays. Moreover, defendants, especially corporate defendants, would be motivated by a loser pays rule to appropriately compensate legitimate claimants with small injuries without recourse to legal process, which would save all the transaction costs of litigation. Finally, loser pays has a surprising additional benefit that should reduce filings of both high-stakes and low-stakes cases. Because loser pays simultaneously reduces the cost of legal innocence and increases the cost of legal culpability, potential defendants are motivated to try harder to comply with the law under a loser pays regime than they are under the current American system. More legal compliance means that fewer potential litigants suffer from negligent injuries or other mistreatment in the first place under loser pays. That's an unambiguous benefit, and it should also produce fewer filed cases. Second, some researchers worry that loser pays would lower the rate at which legal cases are settled before trial. This is a very controversial issue. Some people think that loser pays would reduce settlement rates by raising the stakes of litigation so that optimistic lawyers who had maybe a greater belief than the truth about their chances of prevailing at trial would have a harder time coming together on a settlement figure. On the other hand, a lot of researchers believe exactly the opposite. They think that loser pays will increase settlement rates because risk-averse parties will be more interested in settling in order to avoid the possibility of paying a fee award in addition to a judgment. Who is right depends on whether this first effect, call it the optimism effect, is bigger or smaller than the risk aversion effect. I personally think that concerns about settlement rates are a little bit overblown in the context of this discussion. While it is impossible to say for sure which of these two effects is larger, because they work in opposite directions, one increasing settlement and one reducing it, the net overall effect of loser pays reform on settlement rates is probably going to be pretty modest. And indeed, in countries that have loser pays, such as Britain, France, and Canada, They enjoy very high settlement rates that are quite similar to our own. Moreover, settlements do not always save a large amount of money because most costs are sunk before any trial takes place. This pie chart is a breakdown of the hours that litigation attorneys spend on various activities. Notice that they report spending only 9% of their time on hearings and trials. Most of their time is devoted to activities that frequently precede serious settlement discussions: client interviews, case investigation, pretrial motions, and settlement negotiations. While an early settlement would avoid many of these expenses, settlement on the eve of trial would avoid very few of them. Settlement rates alone, therefore, tell us very little about whether serious cost savings is taking place. By contrast, a policy like loser pays that prevents an abusive lawsuit from being filed in the first place will save the entire cost of that suit. Nonetheless, a carefully designed loser pays reform can and should promote timely settlement, and in a few minutes I will offer you a proposal that I believe accomplishes that goal. A third concern that some researchers have about loser pays is that it might increase the cost of individual trials, even if it reduces their frequency. They point out that each party in a loser pays system expects to cover her own costs only some of the time, and therefore the parties will choose to spend more on litigation, each one assuming that she will get 100% of the benefit of her own additional spending, while only bearing a portion of its expected cost. But this argument simply does not apply to what is called provocative spending, or arms race spending. That is, spending that induces an opposing party to spend more as well. Loser pays creates no new incentive to engage in this kind of spending. And if we look at the pie chart again, you can see that much of the spending that occurs during a lawsuit is provocative spending. Pleadings and motions, for example, trigger responsive pleadings and motions of, roughly similar complexity. Settlement talks, by their nature, require matching investments by the parties. Moreover, there is reason to believe that loser pays would encourage the parties to spend less than they now do on discovery. That's because discovery requests are what I call a hyper-provocative expenditure. They're much more expensive to respond to than they are to file in the first place. That's why under our current system, plaintiffs are motivated to file burdensome discovery requests in order to impose costs on defendants. If we have a loser pays system, the portion of costs devoted to discovery should actually go down. Finally, and I believe most importantly, critics of loser pays worry that it would bar the courthouse door to plaintiffs who have strong legal cases but modest means, because these deserving claimants would be unwilling to run even a small risk of losing a case and being on the hook for a ruinous fee award. If this were true, it would be a very serious objection to loser pays. But this concern is successfully addressed around the world by legal expenses insurance, which insures plaintiffs against the possibility of having to pay a defendant's legal fees. Because over 90% of cases are settled before they go to trial, insurance is surprisingly affordable in loser pays countries. And often, no premium is charged unless the plaintiff either wins or settles the case. Unfortunately, outdated ethics rules here in the United States mean that legal expenses insurance is not unambiguously legal. I think it's very important for lawmakers to eliminate legal barriers to the development of a robust litigation insurance industry at the same time that they pass any new loser pays reforms. Evidence suggests that legal expenses insurance markets can develop very rapidly given the right conditions, as they did in the United Kingdom over the last decade after the government there restricted publicly funded legal aid for personal injury litigation. So I've just offered you a lot of academic research and have reviewed the what-if discussion that surrounds the loser pays debate. But how does all this theory play out in real life? Well, the share of our economy that is spent on litigation is more than double that which is spent in Germany, in France, in England, all of which have loser pays laws. However, these countries differ from the US in many ways, so it's hard to predict from levels of litigation elsewhere what the effect of a loser pays rule would be here at home. Fortunately, while we think of loser pays as a foreign idea, we do have some experience with it here in the United States as well. I'm going to touch just briefly on what we know about our two most significant loser pays experiences here at home. The first is Alaska, which has had a loser pays rule since before it became a state. The evidence from Alaska is interesting but inconclusive, in part because Alaska reimburses prevailing plaintiffs for only about 2/3 of their legal fees and prevailing defendants for only about 20 to 30% of their legal expenses. This is too little to expect loser pays to affect behavior as starkly as my model earlier suggested. Nonetheless, when we compare the composition of civil case filings in Alaska to the rest of the United States, we see some interesting differences that may be related to loser pays. As you can see in this graph here, Alaska exempts family law proceedings from its loser pays rule, and family law forms a 60% share of the civil docket in Alaska, while it is only about a 40% share of the docket in the US generally. Also, torts, an area of litigation particularly prone to abuse, are only 5% of the docket in Alaska, whereas they're twice that large a share, 10% of the docket in the US generally. While this evidence doesn't prove that loser pays has saved Alaska from abusive litigation, it's promising. It suggests that suits to which loser pays applies, such as tort claims, are filed more sparingly in Alaska than elsewhere. It is also significant that most Alaskan attorneys say in surveys that they like their loser pays system and they think that it works pretty well. America's other very significant experiment with loser pays occurred in Florida, where the legislature adopted a loser pays rule only for medical malpractice claims in 1980. The Florida Medical Association and the insurance industry lobbied for this rule, believing that it would reduce abusive litigation. These groups were quickly discouraged, however, by the frequent inability of losing plaintiffs to actually compensate defendants for their attorney's fees. Loser pays was therefore repealed in Florida just 5 years later, in 1985, with all parties agreeing that it had been a failure. It wasn't until several years after repeal that a pair of researchers conducted the first rigorous analysis of the Florida experiment. And their findings suggest that loser pays was given short shrift by lawmakers and by its own early advocates. This chart illustrates the changes they found in plaintiff behavior during the loser pays period in Florida. The biggest difference is that far more malpractice suits were simply dropped under loser pays than under the American rule, 54% versus 44%. Moreover, malpractice cases were only half as likely to go to trial under loser pays as under the American rule, a little more than half, 6% versus 11%. The Florida experiment was flawed because it was not accompanied by measures to encourage a legal expenses insurance market and because it gave judges too much discretion to deny fee awards to successful defendants. Nonetheless, what we do unambiguously know about Florida is that loser pays changed litigant behavior for the better. More abusive lawsuits were dropped early, leaving the courts to focus on a stronger group of claims. So, based on all of the debate and all of the evidence, I believe that loser pays would be a good idea for America. It would better compensate plaintiffs with meritorious cases, and it would discourage abusive litigation. I also think that any loser pays reform should be thoughtfully designed to include 3 key features. First, loser pays should be accompanied by legislation that lowers legal barriers to the establishment of a robust litigation insurance industry here in the United States, similar to those in Europe and other jurisdictions that already have loser pays. This is essential to preserve access to justice for meritorious claimants who have modest personal means. Second, loser pays should be combined with a provision that limits the fees that a party may recover to a percentage of the difference between the amount awarded at trial and the losing party's last written offer of settlement tendered within 60 days of the filing of the original complaint. I know that was a mouthful. This requirement will serve 2 functions simultaneously. It will encourage early settlement by giving the parties a direct incentive to make reasonable settlement offers. It will also contain costs by limiting the fees that a party may recover to a reasonable percentage of the actual stakes of the case. Finally, in order to be maximally effective, a loser pays rule should require plaintiffs to file proof with the court that they have obtained litigation insurance or some alternative way to pay a potential fee award. With a functioning insurance market in place, this should not be difficult for plaintiffs with reasonably good cases. But to ensure as much access to justice as possible, My reform proposal also allows the plaintiff's lawyer to guarantee payment of fees on behalf of her client. The United States pays a high price for a system of justice that uniquely encourages abusive litigation, but it need not continue to do so. Thoughtful reforms in state and federal law can bring our legal system into sync with the rest of the world by adopting loser pays. Thanks for your time, and I look forward to your questions.